Hello everyone, very good evening and thanks for joining with us today. We've been conducting this monthly labor update on all months on last Saturday of the month, but from this time we have started to do it in the first Thursday of the month. So for this month, we don't have any amendments that is being notified. We will quickly move to the circulars and notifications for the month. The EPFO has increased the interest rate to 8.25%. Earlier it was 8.15%. This proposal was put forth in February and the central government has given approval now to credit the enhanced interest rate. Moving to the EPF claims, the online claims that is made by the parties to withdraw EPF. Earlier, there was a mandate that a copy of check leaf has to be produced or an attested bank passbook has to be submitted for the speedy settlement of the EPF claims. Now, the EPFO organization has relaxed the requirement of uploading the check leaf, which was earlier mandatory. Now, the EPFO has come with a different techniques where the claims will be processed once the following criteria mentioned here are fulfilled. One is either the bank, it is direct verification done with the bank. Second thing is the employer will verify using their DSC. Third is Aadhaar seeding. So this proposal was this amendment is now implemented because there are a lot of claims that is being rejected because the applicant is not uploading a copy of check leaf. So in order to make it easier for them, the EPFO has brought this idea to connect directly with the bank by way of a KYC verification. Coming to the private placement agencies, the private placement agencies who provides contract labor to other establishments, they are now to deposit a fee of rupees 5,000 under the heads given under the labor and employment. This service of grant for providing a license is now available in e-portal of their website, where the agency who proposes to provide contract labor workers needs to go enroll themselves and pay the deposit, pay the enhanced fee in order to enroll themselves. This is with regard to NPS, where the NPS has come with a new email ID. EPFO has given a new email ID where you can write your concerns with regard to NPS matters. The Secretary of the Department of Social Welfare Secretary has put forth a concern stating that the transgenders also needs to be benefited in all welfare legislations and schemes, just like how the other male and female employees are benefited out of the welfare scheme. So in order to implement the request and provide programs on transgenders, no discrimination or equal opportunity policy, and to arrange for an initiative to organize programs on sensitization of transgenders. The request was accepted and the Deputy Commissioner of Labor has now nominated head of the office as nodal officer who will provide information with regard to all these schemes and about welfare schemes available with regard to transgenders. Second thing is the admin officer has been appointed as the complaint officer who will look into the grievances put forth by the transgenders if they do have any. Coming to the quiz part of this month, is it mandatory for an employer to paint and or refurbish their factory? If it is mandatory, within time frame of how many years gap the employer should comply with the same. Moving to across the globe session. This is an incident where in a coffee house, the employer has stopped the workmen to come inside the office where they was wearing a uniform given by the union. It is not a uniform given by the management. It is their shirt that is given by the union. So based on the complaint and given by the workman, the court has held that according to the laws of National Labour Relations Act there, it is a violation and the employer is not supposed to stop the workman wearing shirt representing the union to workplace. This is more so when the employer has not given any uniform to the workman. Next is this, we have this interesting thing of flexible working hour request, where now in Singapore, workers are free to request for a 4-day work from home opportunities are already available across the globe. But now 4-day working in a week has now been implemented. So employees are free to ask their employer, and the employer can not reject the same, but the employer can reject only on the ground if it would affect the work that the employee is performing. If that is not the ground, the employer has any other reasons to reject the request of 4-day working other than the business reasons, then the employer cannot reject. All of us have been suffering with this, mainly in the southern region. So Tata has come up with an idea and they have launched a campaign of Beat the Heat. And other companies have also come up with a lot of initiatives such as putting up hydration stations in office, work from home, which is already given, and more so everything has been moved to online meetings, and flexible working hours has been given in order to protect the employees from the summer heat. This is a latest judgment that is pronounced where the applicability of the Permanent Status, Conferment of Permanent Status Act to a corporation. So when a question was put before the court, whether the corporation would come within the term of industrial establishment and whether the employees of corporation can seek permanency under the Conferment of Permanent Status Act. When the employees approached the court, the Inspector of Labour has granted them permanency. Challenging the order, the writ petition was filed by the corporation, which was also disposed of, saying that the act would be applicable to corporation. But the question of whether the employees of the corporation would be entitled to claim benefits under the Permanency Act was remanded back to the authority for him to decide. When the matter was remanded, the authority has granted them the permanent status on sole criteria that they have worked for 480 days in 24 calendar months. Again, second round of litigation went to the High Court, where the writ petition and the writ appeal against the writ petition was disposed of in a common order, stating that the corporation has to consider the employees in terms of the Permanency Act and provide them employment. When the matter went to Supreme Court has once again remanded back the matter to decide on whether the act would be applicable to the workmen of the corporation. Based on the remand, the High Court has once again held that act would apply to the corporation. On an appeal, again, when the management has appealed, the court has held that the union and the court has held that the corporation would form within the term of commercial establishment, and hence the corporation will be liable to grant permanency to the workers. Next, we have an interesting case where a manager working in the bank has employed a driver based on the allowances given by the bank based on the liberty given by the bank for his manager cadre. He has employed a driver, and the driver has filed a case seeking regularization with the bank, and the same was rejected by the court. The employee has not challenged the said order. Subsequently, the employee has filed an application upon his superannuation. The employee has filed an application seeking gratuity benefits from the bank. So when the matter went to the court, the court has held that there is no employer-employee relationship, but the court has granted the employee an ex gratia amount of 75,000, and the bank was directed to pay the same only because of the following reasons: because the engagement of driver was approved by the bank, only because the bank has given the allowance to the manager has engaged a driver. So it is indirectly the bank has approved the manager to engage a driver, and the cost of fuel is a financial responsibility of the bank. Since the bank is offering the offering the reimbursement on fuel and maintenance, so the bank is indirectly liable to pay the amount to the driver. So the bank was asked to pay an amount of ex gratia. Please note, it is not gratuity, it is only an ex gratia. And the liberty was also given to the bank to recover the same from the manager. Coming to the topic of the month, whether an dismissed employee can seek interim relief before the court. The Labour Court or the tribunal under Section 10 of the Industrial Dispute Act has a power to grant interim relief to the workman. This, in most of the cases, the interim relief will be granted, more so because the workman remains unemployed and is struggling to maintain his family during the course of litigation. So in the very first judgment of Hotel Imperial, here the management would have dismissed their workman and filed an application under Section 33. So when the workman filed an application to seeking interim relief, the court would have granted the interim relief to the workman. The question here is, when the application is made for a different purpose, when the reference is made before the Labour Court does not have a provision for this, whether the court can entertain the same. So when the matter reached Supreme Court has held that the Labour Court very well has a power under Section 10(4) of the ID Act, and interim relief can certainly be granted because the matter is always incidental to the question referred to the tribunal or Labour Court. This applies both to the Labour Court and the tribunal. Again, in the case of, this is a case which has been, decision has been rendered following the earlier case of Hotel Imperial. And here the court would have held that the inquiry conducted by the management is not fair and proper. After that, the application is filed and the employee would have stated that he is not gainfully employed, and the application was countenanced by the Labour Court. Again, based on the decision of Hotel Imperial, the power to grant is incidental along with the reference. In the matter of Jaipur Syntax, here the question is again about whether the interim relief is an incidental to the reference, but the only different question that is dealt here in this case is whether the interim relief will be applicable from the date of application made by the employee or the workman, or from the date of dismissal. Here court would have held that in any case, if an interim relief application is countenanced, it is only from the date of application of the workman where he states that he is not gainfully employed and management does not have any evidence to prove that he is employed elsewhere. Then the application will take effect only from the interim relief will take effect only from the date of application and not from the date of dismissal. This is a case where the bank has dismissed employees for misappropriation of money without conducting inquiry, because on prima facie the bank has lost confidence. So the bank has terminated them without conducting an inquiry. When the matter reached court, the bank and the employee, both of them are covered under the Bombay Industrial Act, where the act has a provision that it can get subsistence allowance. So when court held that if the management straight away wants to dismiss the employee without conducting an inquiry, it is the management chooses to do it. So that doesn't mean that if the employer chooses to do it, then the workman obviously has a right to seek interim relief, and the same cannot be rejected just because the management will be given an opportunity to prove the charges before the court by adducing a fresh evidence. Just as much as the management has a right to not conduct an inquiry and establish the charges before the labor court. So here court would have held that equivalent right workman also has to ask for subsistence allowance during the pendency of the proceeding. This is a case where it is a case of an approval application. Even in approval application matters, workmen tend to file interim application seeking interim relief. But here, court would have held that the employer-employee relationship doesn't exist because the management has dismissed the employee, filed an approval application seeking approval for the dismissal. More so, when the approval is being denied by the court, the employer will be liable to pay all the benefits right from the date of dismissal. Hence, in a 33(2)(b) application, the interim relief as sought by the employee would not have been considered on the ground that the employer-employee relationship is gone right after dismissal. This is again a similar matter where the respondent would have stopped coming to work and then has submitted a resignation. Management wanted to terminate him because he was not coming to work. So both went together, and when he tendered resignation, it was accepted as the case of the management here. Matter went to the labor court under section 10. Here, the objection of the management was the respondent is not a workman because he was performing duties of the manager. He's not a workman. When such preliminary question was put forth before the court, without considering it or considering the inquiry, the court would have allowed the application filed by the workman for subsistence allowance. So when the matter reached High Court, it is made clear that without framing any preliminary issue with respect to either jurisdiction or whether the inquiry conducted by the management is proper, if no inquiry is conducted, then management should be allowed to let in evidence and prove the charges. When none of these are conducted before a court, in the beginning itself, an application for interim relief is made. The court cannot assume that there will be a prima facie case, or court cannot assume things and grant interim relief to the workman just because he is unemployed. This is another unique case where subsistence allowance, 50% of his last drawn wages would be given as subsistence allowance, because the management would have not given him a show cause notice for what misconduct he has committed. He was not served with a charge sheet. He was not given any opportunity to speak for himself. So, on gross violation of principle of natural justice, the court would have granted him 50% of last drawn wages. So, coming to the posh corner, here is a case where it pertains to a person who was working in ESI Corporation, where she would have filed a complaint with the Director General against her co-worker, stating that he has been harassing her. But the complaint would not have any statements of what was the harassment, how did the incident happen. where did it happen, what was that she has gone through. So when she is primarily filed an application to withhold his retirement benefits. So when the IC looked into the complaint and inquired, the IC was also unable to extract what is the content of communication or what has happened. So the IC merely recommended that it is best that petitioner and respondent do not work together and they is relocated the working place. When the report of committee based on the report of committee, the committee would have been very clear in their report stating that when the petitioner has filed a complaint, the petitioner was unable to answer who are the witness, any eyewitness present during the incident, or the committee would have examined as many as 8 or 9 witnesses, where none of the person were able to say even any supporting statements with regard to the allegation made by the complainant. So the IC, even when questioned by the petitioner also did not disclose anything in the complaint. Later, when she was given a chance to present her case before the IC also, she did not come forward to disclose whatever happened in full. So the IC has held that there is no justification to believe her complaint and it is to be a false complaint. Based on all the IC report and the hearings, the court would have imposed a fine of rupees 50,000 on the complainant for filing a false complaint and misusing the powers given to women in the POSH Act. To answer the question of this segment, yes, it is mandatory for an employer to paint and refurbish the factory. It should be done once in 5 years. This is mandated in section 11(1)(d) of the Factories Act. The complaints calendar for the month is here, and we'll be sharing the PPT. You can refer to the complaints dates. Okay, thank you everybody for connecting. If you have any queries, you may please feel free to write to this email ID. Let's again connect on 4th July at 5 p.m. Thank you.
Thank you.
Thank you, madam.
Thank you.
Thank you very much.
Thank you very much.
Thank you very much.
Thank you.
Hello.
Thank you. Thank you very much.
Thank you very much.